Welcome to Embargoed, a podcast featuring intelligent talk about sanctions, export controls, and all things international trade for trade nerds and normal human beings alike. I am one of your hosts, Brian Fleming, and I'm here with my friend, co-host, and colleague, Mr. Tim O'Toole in DC. What's up, Tim?
What's going on, Brian? More of the same.
Yes, things here in Maryland / the Tower Room at Baker Library are great, or as great as they can be under the current circumstances. So good to see you virtually via Zoom.
You as well, especially on a Friday afternoon.
On a Friday afternoon, it's been a long week for both of us, and we're recording this on Friday, April 24th. And it is 5 o'clock somewhere, though it's not quite 5 o'clock in Washington, D.C.
This is all that stands between us and happy hours.
But by the time this is over, it will be. So that's exciting for both of us. So welcome to the latest episode. As usual, the normal disclaimer: we're not here giving legal advice. We're not sharing any confidential information. We thank everyone who responded to the FAQ podcast that we put up a couple weeks ago. I think that was a fun one to do. We're back to sort of the normal format this time. Before we get started, I think the only thing I'll say is, as always, please, if you like the podcast and you're checking it out, please subscribe, give us a rating, hopefully a 5-star rating. You can find us Apple Podcasts, Spotify, Google Play, Stitcher, Overcast, YouTube, wherever you get your podcasts. And I would also add, as a little teaser for next time, in 2 weeks we're planning to do a full China-related episode. So we're excited about that. We've already got a lot of great ideas of what we're going to cover there, and I think it is going to feature the very first guest in embargoed history. So he's a tough person to line up. He's in high demand, but I think we're going to be able to secure him to join us. So we will hopefully have that in 2 weeks. So that's a little tease for you.
Well, let's keep that guest identity secret,
yes,
at least for now, because we don't want to overpromise.
That's right. He also might stand us up at the last minute. We might have to apply some pressure to get him to come on. But in any event, so 2 weeks, China all the time on the next episode. And so I think with that, we're ready to get going here. We're gonna run through. We're kind of back to the normal format. We're gonna run through several topics in a little more detail. We're gonna start with a few COVID-related topics and then pivot to a few unrelated sanctions topics, and then we're going to do the lightning round, and that'll be all she wrote for today. So without further ado, let me get us started with item really 1A. This is really 1A and 1B. These are sort of two OFAC related items that we're going to start with. And for this, I want to make sure that I pull this up so I have it in front of me. So we're recording, as I said, on Friday, April 24. Earlier this week, on Monday, OFAC issued on their website a little notice, and anybody who gets the OFAC is on the OFAC mailing list saw this, no doubt. And it was titled "OFAC Encourages Persons to Communicate OFAC Compliance Concerns Related to COVID-19." So that's the headline. And then they proceed to sort of identify a number of different situations where it may be necessary for folks to be reaching out to them, whether it be potential delays or trouble in filing blocking and reject reports within the time period allotted under the regs, responding to administrative subpoenas, things of that sort. And then they have a whole bunch of contact info listed. Hopefully, we would hope that most folks out there have been proactive about these types of things. I know that we have been talking to folks at the agencies on behalf of our clients pretty frequently in the last month, due to any of these types of reasons, disruptions and other things that are just making it challenging for us all to sort of exist and operate these days. But the thing we want to focus on is the last paragraph of this little very short notice that OFAC included, because I think this is this is notable. So I'm going to read this verbatim, and then I'm going to turn it over to Tim for his thoughts on this. So the last paragraph of this reads, OFAC understands that the COVID-19 pandemic can cause technical and resource challenges for organizations. As OFAC has articulated in both its economic sanctions enforcement guidelines and its framework for compliance commitments, the agency supports a risk-based approach to sanctions compliance. Accordingly, if a business facing technical and resource challenges caused by the COVID-19 pandemic chooses, as part of its risk-based approach to sanctions compliance, to account for such challenges by temporarily reallocating sanctions compliance resources consistent with that approach, OFAC will evaluate this as a factor in determining the appropriate administrative response to an apparent violation that occurs during this period. OFAC will address these issues on a case-by-case basis. So, Tim, Professor O'Toole, I'm turning this over to you. Please translate OFACese into English and explain to our listeners what that means.
First, I liked, Brian, how you paused on the OFAC understands. Because really, if I were to use one word to describe OFAC, it would be understanding. And I think that's universal sentiment on that. But so let's translate this a little bit. I mean, let's start out with this is not a pass to essentially shut down your compliance program during the COVID pandemic. So it's not a pass. If you, and we'll talk about an enforcement action later on today where a company got in big trouble because their compliance program was pretty woefully inadequate. So that is still the rule, that you've got to have a risk-based compliance program. But I was making fun of them a little bit, but the fact is that OFAC expressing that it understands that sometimes in a risk-based approach that there will be bigger risks than compliance is a big deal. And I also think that it's pretty smart of OFAC, because I do think that the crisis has created strains and stresses on compliance programs for all the reasons that we've talked about in prior episodes that have created a lot of anxiety within compliance programs about what they can and can't do. And I think this is a message, a signal from OFAC that it understands what's happening and that it is sympathetic to that, not too sympathetic. There was an article on this in the Wall Street Journal, and there was a discussion by some yahoo about how this was a positive approach by OFAC by providing some guidance, and there was a caution from somebody in the article as well that this is not a hall pass. This is not like a get out of free jail card, and I completely agree with that. But I still think it's important, because if OFAC is out there saying that they understand, I think it will make companies' compliance programs relax some, which they need to right now, but not go out of control and just basically go out to lunch.
Yeah, I think so. For the inside joke there is that Tim was the Yahoo that was quoted in the Wall Street Journal article. So a couple of observations. This is obviously something we talked about on prior episodes, where I think 2 episodes ago, where we first tackled the sort of what are the practical challenges to dealing with compliance in these times. And this is exactly what we were saying, is that, there's feeling sort of trapped or restricted by the circumstances that everybody's dealing with now is just not the right way to think of it. It has to be thought of holistically as part of the risk-based approach. If there are going to be modifications made, again, I'll reiterate this, we said this before, but that should be documented, that should be thoughtful, that should be done in a way that is, again, if down the road people come and ask questions, if OFAC comes and asks questions, that there will be a record of that, and hopefully it'll be clear that this was all done after due consideration and in light of, again, all the relevant risk factors. So that's certainly something we would encourage. I would also note that I saw, I think yesterday or the day before, there were some officials from DOJ and SEC who essentially said the exact same thing with respect to FCPA compliance, that this isn't a hall pass. However, we understand these are complicated times we're all in. Compliance is much more difficult when it's all being done remotely, and there are resources being surged to deal with bigger immediate issues that have to be dealt with by companies at the moment. And please keep the lines of communication open and talk to us if you're having trouble, complying, or you're fearful that by shifting or reallocating resources, you're potentially going to be opening yourselves up to missing something, or maybe you're only catching a red flag 3 months from now, as opposed to a week or a day from now, as you might on normal times, right? Those types of things. So these are things that the regulators and enforcers always say, which is come talk to us. That's been said since the beginning of time, but it's I think again the fact that they're putting this out there so explicitly, at least as a symbolic gesture and a kind of cue to the compliance community, that is meaningful. And so I think that's really the big thing that we wanted to sort of hit on here. And I think in that vein, so to sort of pivot to 1B of this issue, and I'll turn it to Tim to introduce this, OFAC did sort of a similar thing on another topic that we've talked about recently, which is the sort of humanitarian assistance sort of exceptions and exemptions that exist, and general licenses that exist out there to provide humanitarian assistance in many countries that are at the moment both ravaged by both sanctions and COVID-19. So I'll turn that to Tim to introduce that.
Yeah, I mean, this is another kind of recurring theme in terms of the podcast, especially after COVID hit, is that it has created huge challenges in sanctioned countries, even though the actual delivery of humanitarian items are not subject to sanctions. The sanctions themselves have deterred that, have interfered with that. There have been plenty of charges out and around the world from the Pope and from the UN and from various people in the sanctioned countries and from their allies, all talking about the way that U.S. sanctions are interfering with the provision of humanitarian assistance. And it's clear that the U.S. and OFAC have been sensitive to that. And I think that is the motivation behind this April 16th fact sheet on the provision of humanitarian assistance and trade to combat COVID-19. Basically what the document does, and it's again, OFAC being kind of sensitive to what's going on in the world, is it lays out all of the pre-existing ways in which humanitarian trade is permitted despite sanctions, and it does it on a country-by-country basis, along with all of the different general licenses, that is the generalized permissions that OFAC has in each country's sanction program to allow for the provision of humanitarian goods and services. It actually goes through and talks on a pretty much item-by-item basis. I mean, the Iranian discussion it reflects this, but it talks about how most medicine and medical devices, including certain personal protective equipment and other items used for COVID-19 related treatments, such as gowns, eye shields and goggles, surgical gloves, face shields, respirators and masks, and including N95, N99, and 100 masks. I mean, I think you can get the gist of this. They talk about how all of these goods are potentially within pre-existing humanitarian exceptions to the sanctions on Iran, gives some guidance about what other ones might not be within that, more advanced items that might not be within the exceptions, but that OFAC would have a favorable licensing policy depending upon the circumstances. So it really is kind of a detailed how-to in terms of exporting humanitarian, particularly medical goods, but also food and agricultural commodities into sanctioned countries. Nothing new. So it was all things that had already been created, already in existence.
Yeah, interestingly, I think so two things. Interestingly, I think it basically, the country by country pertains solely to the sort of most heavily sanctioned countries in the world, right? It's sort of Iran, Venezuela, Cuba, North Korea, Russia, Syria. Those are, I think, the 6 countries that are referenced in the fact sheet. And as you said, nothing new. It's just an interesting kind of compendium of information. The relevant FAQs are referenced and linked to all of the general licenses. Like it's all just nice, neatly packaged up in one place. And as kind of a symbolic gesture, and as maybe a useful, piece of, paper that could be forwarded to a bank or an insurer or a freight forwarder or somebody who was potentially being resistant in the attempts to get humanitarian goods to one of these countries. It could be a useful tool in that regard. I have to say, one thing that occurred to me, and this is not the only time this has occurred to me, and it's not solely related to OFAC, is I wonder whether this is a product of the lockdown and the shutdown, and nobody has anything to do, so they're just putting together these compendiums and these fact sheets because they're at home and they can do these types of projects now. That's perhaps a little too cynical a view of it all, but it is kind of odd that there's been just a ton of these that have come out all across the board in the last couple of weeks.
To put this in law firm speak, it appears that OFAC is catching up on its GOB at this point because that some of the other work has lightened up. I agree with that, and I also think to me it's kind of odd because although I think the public was the audience for the announcement that OFAC had done this and that there are humanitarian channels, and I saw a press release about how the U.S. is leading the world in providing humanitarian aid in the time of crisis and kind of accompanied this. I do think this was mostly for the lawyers. I don't think that anybody who's not a sanctions lawyer could read that fact sheet and really understand what the hell is going on. I mean, they have a compendium of like 27 general licenses that apply to the Iran program, and most people, I think, most normal people would look at that and say, "You lost me a general license." And so I do think it's kind of for the lawyers who do this stuff to be able to kind of quickly get answers to clients and then also to be able to write kind of confident opinions that this is something that OFAC has interpreted to apply to these particular items in terms of humanitarian.
Yeah, and again, as we've talked about in the past, to the extent that there are sort of practical obstacles to the free flow of humanitarian trade right now, or really even during normal times, in part because banks and insurers and logistics providers and freight forwarders and et cetera are so sort of risk averse when it comes to any trade with these types of countries that are so heavily restricted under OFAC and other rules and regimes. Again, this is sort of a bit of a signal, or I think, to that community as well, that and their compliance folks, hopefully, that this is something that is being taken seriously and is not just going to be sort of perhaps the normal sort of stringent rules that would apply to your vetting and your due diligence and all the rest of it. Or you may not be willing to take any, Iran business or any Syrian business under consideration under normal times. With something like this kind of at the ready, that's, again, trying to be, I think, as a symbolic matter, something that's signaling, no, the U.S. government is serious, that they want to permit this type of trade, this type of authorized trade. Maybe that moves the needle a little bit for some people. It's hard to say, but I think that's sort of the other piece of this.
Yeah, no, I mean, I was joking a little bit before, but it is nice that OFAC seems to have some sort of finger on the pulse response to what's going on in the real world and is responding relatively quickly to that. And I also was joking about the Wall Street Journal articles on this, but I thought that Menchi Sun did a really good job in the series of articles about kind of what the compliance challenges were and what it would take and what should be done in order for the regulators to respond to them. And so, this is good to see. I'm not sure how big a deal it is in the great scheme of things, but I think it's definitely more helpful than not.
Yeah, and for people like us, it's a handy reference tool to have it all in one place, right? I mean, I think I've already looked at it several times since it came out, just because it's nice to have all the the rules and the FAQs and the general licenses all in one document. So
yeah, that's why I do think it's, I mean, to me, it's most helpful for lawyers because I get these questions all the time, and this just makes it easier to answer them. You can answer them more quickly because it's all in one place. And,
right.
you know, we had that of our own because we had already written memos on a lot of this stuff. But this also makes it easy to be more authoritative because you essentially attach that memo to your memo and
Right.
say, here's what OFAC says about it. And so, well, you know, some people take us more seriously than others. Everybody is going to take OFAC seriously on this, and
Right.
so it's helpful.
Yeah. Okay. So with that, let's leave sort of OFAC's you know, at home catching up on old email requests from their supervisors' work and put that aside for the moment. And let's move on to the next item, which is a bit of an update on something we talked about just the last time relating to the export restrictions that have been placed on personal protective equipment through a temporary rule issued by FEMA. And so the news here is when we last recorded, this was 2 weeks ago, and at the time we had the initial rule that was issued via Federal Register notice, and we had some sort of interim guidance that had come out from Customs and Border Protection the following week. Now what we've gotten just a couple of days ago on April 21 was another Federal Register notice that does something important, which is it sort of codifies and spells out in more detail exemptions to the temporary final rule. And this is something that we talked about the last time. I think there's a couple of, I won't sort of read through all of them. There's 10 new exemptions that were included in this Federal Register notice that was published on April 21 relating to the covered PPE materials that would be subject to these export restrictions pursuant to the Defense Production Act and the rule that's been issued by FEMA. I think the big takeaways, and this kind of builds on what we talked about last time, was you know, the fact that this is commercial focused, right? That the rule is meant to really police and detain commercial shipments of these materials that are going out of the United States. So the exemptions are really meant to clearly define a number of areas and a number of instances where, you know, there is no real true commercial purpose to the shipment, and some of them deal with and again, some of these build on the exclusions that were included in the CBP memo from a couple of weeks ago. Some of these are sort of new, and so would encourage everybody to go the full list of exemptions if this is something that applies to your company. But at the end of the day, the sort of non-commercial aspect has now been kind of codified in these exemptions, and sort of two that I'll reference quickly that I think are significant. One is relating to what we were just talking about, which is humanitarian assistance. So there's an exemption for donations being made by nonprofits and NGOs to either foreign charitable organizations or foreign governments. And those are not to be resold by those entities, but just for use in those countries. Essentially, that's one. And then another is intra-company transfers from U.S. domestic facilities to their foreign facilities for use by their workers in those foreign countries. And the last thing I'll mention, which is sort of a procedural issue, and I think we talked about this the last time, now it's been spelled out in detail as a requirement under the new rules, is this idea of having to provide a letter of attestation if you're going to claim certain exemptions. So the charitable donation exemption and the intra-company transfer exemption that I just mentioned, those two are two that require a letter of attestation, which has to be submitted via CBP's document imaging system and has to include certain information to verify that you are able to claim the exemption that you're trying to export under. So again, for people that are where this is impacting you and your business or your organization, if you're a charitable organization, I would encourage you to just take a close look. To FEMA's credit, to CBP's credit, they've been very good about evolving the guidance on this and developing these exemptions pretty quickly. we've published a little piece on this the other day, an alert for our clients. And, I think rightfully so, we gave credit to those organizations for reacting swiftly to bring some clarity to an area where, quite frankly, when the initial rule was published, there was not much. And it looked like this could be a very broad rule that was going to affect a lot of different shipments and potentially detrimentally. And to their credit, they acted quickly and have now clarified some of that. So that's really all I have to say about that. And I'll throw it to Tim for some thoughts as well.
Yeah, I mean, it's a similar story to item 1A and 1B, where we've talked about this for a while. We talked about this for, about the unusual situation in which there are restrictions on the export of personal protective equipment. Normally, that is one of the least restricted commodities. Other countries started to restrict it as they started to suffer from the pandemic. The U.S., as we talked about earlier, adopted these emergency measures to restrict the export of PPE. And as you noted, Brian, the progression was pretty logical and pretty fast. So first, with this brand new set of rules and a brand new agency that had been authorized to implement them, FEMA and CBP, which are not normally in the export business, the first question was, okay, so what does this cover? What is restricted to domestic use? That was answered relatively quickly in terms of kind of what they were going after. Then are there exceptions? Yes, and those have been developed pretty quickly over the last 3 weeks and really kind of firmed up in terms of what they are. And then the third question that pops up is, well, what's the process for invoking the exemptions? And as you pointed out, Brian, at first, nobody had any flippant idea what the process was. It was just like, I know that I have an exemption, how do I get it? And now pretty quickly it's evolved that you will have to declare the exemption through one of these certificate of attestations, at least for some of the exemptions, and that they apply differently, that there'll be a joint implementation by both FEMA and CBP, where CBP holds the goods and then FEMA lets them go. And so over the course of less than a month, the U.S. has implemented a new law that it didn't normally have. It charged two agencies with handling how that law was going to work, and those agencies have come up with some relatively rational rules and a process for handling the restrictions. That's been pretty quick. I mean, we'll see how it plays out in the real world, but in terms of rulemaking and agency responsiveness, it's a pretty good story.
Yeah, agree. And the last word I would add on this is just that because it is so new, and because these new exemptions have just been published and made public this week, for anybody who's moving quickly on these issues and needs some guidance, FEMA and CBP in particular have been very responsive and very helpful, getting various officials on the phone who are noted in some of the guidance and the register notices. Not that I want to have them flooded with calls and emails, but we've certainly been in touch with them. I know a lot of people have. So would encourage people to reach out if there's any ambiguities or questions, just because obviously this is important, and it's not something that you want to have hung up sitting in at an airport facility or a port waiting to be exported someplace that really needs it. So with that, I think we'll leave PPE alone now and pivot away from COVID to a different topic. I wouldn't say necessarily a happier topic, but a different topic, which is Venezuela, and in particular the new general license that was just issued this week.
Well, in keeping with our themes, we have talked about Venezuela quite a bit on the podcast, and the increase in sanctions, particularly sanctions targeting the Venezuelan oil industry. I think that the main goal of the maximum pressure strategy seems to be to cut off Venezuelan oil exports, particularly those oil exports that result in any sort of benefit to the Maduro regime. Despite that, since the sanctions really ramped up, and since PDVSA, Petróleos de Venezuela, went on the SDN list back in, I believe it was January of 2019, the OFAC has created an exception that allowed for certain joint ventures between companies with a U.S. nexus and PDVSA to continue to operate in certain ways in the region. And so that had resulted in something called General License 8, which I believe we've actually referenced on the program in episode 3, that kind of spelled out what certain companies, including Chevron and some others listed on the general license, could do in Venezuela. And it was a lot. It was basically, if the contracts were in effect before PDVSA was designated, the companies could take all sorts of actions to maintain and really carry out and effectuate those contracts and any actions ordinarily incident to the carrying out of those contracts until recently. So those general licenses were all time limited. There was one that came into effect, I believe it was in January, was the
last one was in January. Yeah, last one was in January.
So we had one in January 17th, that was pretty broad, and that expired April 22nd. So it was just about to expire, and on April 21st, OFAC renewed the general license 8. 8F is the renewal, but it is substantially less broad than the other ones, and really is designed to wind down as opposed to
drastically narrowed, I think, is probably the best way to put it.
And so before, it was all transactions ordinarily incident to contracts that were in effect when PDVSA was designated. Now it's all transactions that are ordinarily incident and necessary to the limited maintenance of essential operations, contracts, or other agreements that are for the safety or preservation of assets in Venezuela, involve PDVSA or any entity in which PDVSA owns a 50% or more interest, and were in effect prior to July 29. So it's essentially essential operations, and they have to be for safety and preservation.
Yeah, and later on in the general license, they make very clear that what is not authorized is drilling, lifting, or processing of petroleum. So right. That's basically game over for any kind of operations that were ongoing in Venezuela for any of these entities. And
even that expires December 1st, 2020. So that is only 6 months. Now it could be renewed, but it is a wind down and only essential operations license, as opposed to, as long as your contract was in place before January 2019, you can continue to operate on it.
Right. Yeah, I think the biggest things are this. So, like we said, it's a drastic narrowing of the general license. It's essentially the sort of the death knell, at least for now, of any continued business for Chevron or these other entities in Venezuela. And it's as Tim said, it's for literally safety and asset preservation. Those are sort of the two bases that are cited as what's permissible, essentially, in terms of continuity of operations for the next 7+ months. When we talked about this back in February, I think if I recall, the context there was there had been some reporting and some noise that the U.S. government was ready to shut down this general license, and they were ready to say, okay, Chevron's going to have to stop operating down there, and we're going to get rid of this general license. What it seems has happened, and this is in some, I believe Reuters had this in some of their reporting. They were one of the first to report on this. This is a bit of a compromise, right? Because there's a 7-month wind down period, which is a little strange because that's a long. It's a long time. It's not immediate. It's not 30 days or 60 days, which is pretty typical for some of these. And as we discussed on the most recent episode or the last couple of episodes, there's a lot going on with respect to Venezuela at the moment. There's the plan, the transition plan that the U.S. is backing, and the sanctions relief that would go along with that. Now, as we said at the time that we discussed that originally, it's hard to say that we think that has a great chance of really moving forward in any meaningful way in the near future, especially in an election year and with the coronavirus pandemic and all the rest of it. But it does strike me that with a 7-month window until this general license expires, that there's at least the chance that there could be some material change in what's happening with respect to Venezuela, what's happening with respect to the Maduro regime. The Guaido regime talks about a transition government. and many other factors, right? So a lot could happen in the 7 months. So we'll have to see what happens. But I think that certainly the way it's being reported now is that this is basically the end, and this is the U.S. kind of choking off this another valuable revenue stream that remained for the Maduro regime after a lot of consideration about that, and that sort of plays into the broader strategy that we've been talking about, which is maximum pressure, even if this is potentially going to be harmful to some U.S. interests and is going to potentially kind of eliminate one of the last meaningful kind of footholds that a big U.S. company had in Venezuela, at least for the time being. It was apparently deemed to be necessary to sort of apply that additional pressure and to hopefully end up in the situation that the White House and the administration is hoping, which is that Maduro is either comes to he and his people come to the table to talk about this transition government, or perhaps he's captured on the outstanding warrant for his arrest with regard to the narco trafficking, or something big happens in the next 6 months or so.
Yeah, I mean, this has all the appearances of an endgame type measure. Yes. Where you're essentially trying to get to checkmate, but you're not quite there yet, because as a practical matter, and I think we talked about this back in episode 5, so you have these joint ventures between Western companies, including US companies, and PDVSA to help develop the Venezuelan oil fields. These companies, these Western companies, own parts of the oil fields. And if they abandon those oil fields, if they're forced to abandon them by the sanctions, PDVSA is just going to take the oil fields, and it's going to figure out a way to develop its own oil field. And so essentially you're ceding the turf to PDVSA if this turns into a long-term standoff. In the short term, it puts pressure on PDVSA, it puts pressure on Maduro, it cuts off the spigots. They need to make a move. But if they survive in the long run, you've actually given them more assets rather than fewer. And that doesn't seem like a good strategy if you're really trying to make them suffer. In the short term, it'll give them a lot of pain.
Yeah, I mean, I think, again, that's just back to what we said a few minutes ago, sort of safety and preservation of assets, right? That's kind of what's still permissible. So it's hard to say. And I mean, there's so many things to balance here in terms of what that really means for the sort of operational folks on the ground from these companies. And it's incredibly, this is a situation that's obviously incredibly fraught and incredibly difficult to navigate, and personal and physical safety is a big issue that's in play with all of these situations down in Venezuela at the moment, but not to mention the virus on top of it, right? So a lot of complexity to manage, a lot of moving parts here, but in any event, another important move, I think, to your point on sort of the chessboard and the end game that the U.S. is trying to play in terms of choking off another valuable revenue stream for Maduro and his folks, and so we'll see how it plays out. But I think this is one that will clearly be worth tracking, and over the course of the next 7 months, I'm sure we will be coming back to it at some point. So with that, let's go to our last sort of major topic for the day, which is another. This is another OFAC and others in the U.S. government apparently having time to sort of clear out the backlog of their homework assignments. So this is sort of, now we're going to pivot to North Korea, and we're going to talk about two items that have been published in the last couple of weeks. So the first being North Korean cyber guidance, which was actually a joint product that was put out by the State Department, Treasury, Homeland Security, and FBI. And it's an interesting piece of work product. And then separately is the UN report from the panel of experts relating to essentially the North Korean sanctions evasion in the maritime space and the finance space, sort of across the board, and all of the activities and all of the evidence that's been collected on those efforts over the past year plus. And so I'll start with the cyber advisory for a moment, and then I'll flip to Tim to talk more about the UN report. But the cyber advisory is almost in the way that the humanitarian assistance fact sheet is, I mean, there's not really any new news here. It's just sort of an interesting collection of information and facts that, to me, is clearly meant to be, this is going to a global non-US audience in large part. And it's sort of laying out the case for all of the bad acts and the malign activity that the North Korean regime has been sort of responsible for in terms of malicious cyber behavior and hacking activities. There's a list of attributed malicious cyber activities that the North Koreans have been involved with. There's some talk about some of their, sort of compliance and other cyber best practices that people should be aware of to sort of combat these types of efforts. Encouragement to come to the U.S. authorities if there are signals that people see of this type of activity. There's a pretty lengthy section that reminds everybody that if you're involved in materially assisting any of these actors or helping them evade sanctions, that you yourself could be subject to sanctions and significant and even criminal penalties in the U.S. So it's a little bit of a hodgepodge of different kind of perspectives and information on the North Korean cyber threat generally, I would say, with, again, kind of, and there are a few matters in here that are cited that we've talked about in recent episodes relating to some of the cryptocurrency sort of heists and shenanigans that the North Korean cyber actors have been up to, and things relating to other financial institutions and other things of that sort. So I think it's really it's an effort to sort of cast in one place a powerful message about the threat that this really these actors present. And I would say that in the U.S. view, the fact that this type of product is being put out there, on the cyber side of things, it's sort of China, Russia, Iran. Those are kind of the traditional biggest threats that have been talked about for years. And North Korea increasingly has been sort of elevating in status, just given the sort of level of the activity they've been engaged in and some of the high-profile activities they've been engaged in. But it hasn't been maybe as front and center on the radar. I mean, people know about Sony Pictures and that which was attributed to North Koreans, and which there was a criminal case related to that was brought thereafter. But perhaps not as much in the U.S. or in the global community. So I think that that's kind of the most meaningful thing. And I think linking this with the UN report, it seemed likely to me that it was timed to coincide with the publication of the panel of experts report on North Korea to have kind of maximum impact and maximum visibility. And there's actually a link in the annex to the cyber advisory to the UN report, and that sort of. And while the cyber advisory is, 10 pages long or something, and like I said, is not really a lot of new information, it's just all collected in one place. The UN report is obviously quite extensive and is kind of linked explicitly to the cyber advisory. So I don't know what your thoughts are on that and what this all kind of foretells for where North Korea's place is in kind of the general kind of risk matrix of sanctions and cyber and other sort of nefarious activity that we see all the time.
Yeah, I agree with you that the cyber report was geared towards an international audience, and I've continued to be impressed in many ways at the level of international consensus on this sanctions issue as opposed to many other sanctions issues. The UN report that you've been talking about, the UN imposed a series of escalating sanctions against North Korea because of its nuclear and ballistic missile programs, and was able to get all members of the Security Council to go along with those sanctions. This was before the negotiations developed between President Trump and Kim Jong-un. And that when the UN establishes a sanctions program, it creates a panel of experts. The panel of experts does periodic reports on, whether there is sanctions compliance and whether or not the behavior that was designed to be deterred by the sanctions has actually been deterred by the sanctions. And so this was the panel of experts that oversees North Korea's most recent effort. They've done a number of reports, but this one I think was probably the most extensive one. And it documents in pretty extensive detail the ways in which North Korea is continuing to violate sanctions through the imports of petroleum. There's actually, it's allowed under the UN sanctions for them to import 500,000 barrels of petroleum products in a certain period, but they have, according to the UN, exceeded that level many times over. They've also been, there's limits on their exports under the UN sanctions, and they have been exporting apparently most heavily coal and sand to various countries, and importing luxury goods, which are also prohibited under the UN sanctions. And so it documents all of these particular violations in pretty decent detail. What I think is most interesting on it about this report is that really I've read some of the prior reports and there's not a lot of controversy about them, but on this one, both Russia and China objected in particular to the section of the report that dealt with the oil sales to North Korea, and even in the summary, I think insisted on a sentence that said Russia and China requested more conclusive evidence to make the judgment. And so essentially, there is some of this consensus appears to be breaking down, I think most notably because a lot of the sanctions evasion that is documented in the report seems to be with either the implicit participation of China or the explicit participation of China. On the exports, China is the country often where the sand and the coal are being exported. On the oil, a lot of the exports are coming either from China or through China. Since China doesn't have a lot of oil, I guess it's more through China. But I think that, to me, the consensus that has kind of led to these sanctions and the way that have been enforced until now is pretty interesting. And I think that the U.S. Report on cyber is kind of to get out there to the international audience, most of whom is taking the North Korean threat seriously, that there's another aspect to this. This isn't getting any better. It's actually getting worse.
Yeah, no, I think that's right. I think the sentence does sort of come jumping out at you about Russia and China wanted more conclusive proof. That's just kind of, in a nutshell, I think speaks volumes about the fractured nature of geopolitics at the moment. So, yeah, I think that's exactly right. It is as Tim said, it's a tome. It is the UN Panel of Experts report, and very detailed. So for those who are interested in learning more about the North Korean sort of threat generally and sanctions evasion techniques, I think the advisory and the report together are a good starting place there. And so again, it was striking that these two things were kind of all coming out together and again, seemingly coincided to make kind of maximum visibility on this. So I think with that, we'll conclude with sort of the main portion of the podcast for today. And then we will now turn, after a pretty sweet sound effect, which I will pause for, to the lightning round. And with that, I will turn it over. Oh, Tim almost got hit by the lightning. He got out of the way, thankfully. So with that, I'll turn it over to Tim to introduce our first lightning topic of the day.
All right, so this is going to be very fast because it is the lightning round. But the first lightning topic is an enforcement action against the Industrial Bank of Korea. IBK entered into a deferred prosecution agreement with the Southern District of New York U.S. Attorney's Office. It was a case that was also, and I think, instigated by the Attorney General's Office in the state of New York. And it started out, when you read the first part of the statement of facts that accompanies the deferred prosecution agreement, in which IBK agreed to pay $86 million, it's really a discussion about a lousy money laundering compliance program, and you're starting to think, how did this turn into a criminal case? But essentially, you had a compliance program for a pretty large bank that had branches in the United States that was manual, and when it was audited by the New York regulators, it got failing grades for a number of years. And after these failing grades, it didn't really do anything to improve its compliance program. And after about a year or two after the failing grades, a U.S. Citizen named Kenneth Wong worked with some Iranian groups to essentially get a lot of money, about $1 billion in transactions, out of the IBK accounts in Seoul that were being held there. They were the sort of accounts that are created through U.S. sanctions, where they're essentially monitored accounts that allow for payment for certain goods, for trade between non-U.S. trade between certain countries and Iran. And so the IBK had set up an account that allowed for some sorts of Korean trade with Iran, but the account was very restricted. And if you have a good compliance program, you'd be able to enforce those restrictions. But they did not. And so Mr. Wong, working with the Iranians, was able to get about $1 billion out of the account before somebody in the compliance group at IBK discovered it. It took about 5 months for them to discover it. Once they did discover it, if you read through the report, it's almost like a comedy of errors in trying to shut it down. Ultimately, including the compliance people saying like, OFAC is going to be really mad at us for this. And in fact, when OFAC and actually the New York regulators found out about it, they were pretty mad. And so I think it's a good example of kind of what can happen if you have both a bad compliance program, the regulators tell you to fix it, and you don't spend the resources to fix it. Eventually, you're going to have a big issue. And here, they had $1 billion issue that resulted in $86 million in penalties.
Yeah, I think that just very quickly, I think that, the underlying charge that's the basis for the DPA is actually a failure on the AML side and a violation of the Bank Secrecy Act. But that failure led to, exactly as Tim said, $1 billion in US dollar transactions that violated the Iran sanctions. And so that is obviously a big deal. I think in addition, the one other data point is, in addition to the manual process, no automated screening, and there was one compliance officer that was based in New York, who was somebody that apparently had no prior experience, and also was kind of raising the alarm bell that this was a problem and this was inadequate, and they needed more resources and they needed automated screening. And so in addition to the regulator, this internal compliance person was also sounding the alarm. And as we've seen in many prior enforcement actions, if your own compliance people are telling you to do something and you just ignore it, that is a recipe for disaster. And so I think that's kind of another takeaway here. One other last observation is, this shows, I think, how AML compliance and sanctions compliance, these are things that are really not quite one and the same, but they go together like peanut butter and jelly. I think if you're thinking of them separately, I think that's a mistake. These considerations and the things that need to be done to ensure that your entity, your bank, what have you, is not running afoul of these problems. They all go together. They need to be thought of holistically in addition to other compliance considerations. And I think this is a good example of that, and where those things were not thought of sort of as one.
Absolutely. I mean, I think when you look at a criminal indictment now in the sanctions context, there's almost always a money laundering component to it. And so there's at least one or two money laundering charges. Sometimes it's the main charge. Often it is the charge that is designed to allow for extradition, because although many countries don't adhere to U.S. sanctions, particularly with respect to Iran, virtually all countries now have anti-money laundering laws that are similar to U.S. laws. And so if there is an anti-money laundering charge, that will allow for extradition much easier. And so there really is almost no daylight between what's required in the money laundering context in terms of compliance and what's required in the sanctions context in terms of compliance.
Yeah, no, I think that's right. That's a good point. So with that, let's that's about as much as we can handle for lightning speed on IBK. So let's move on now to number two, item number two in the lightning round, which takes us to Cuba, and in particular to South Florida, where there was an order last week in a couple of ongoing lawsuits that were brought under Title III of Helms-Burton. So we've touched on this briefly before, but for those who are unfamiliar, just over a year ago, the Title III of Helms-Burton was activated because the president chose not to exercise waiver authority. And what that has allowed is for litigants to bring suit against parties that have been involved in using confiscated property that was seized under the Castro regime when they took over in the late 50s, early 60s. And so this was literally one of the first, these are among the first lawsuits that were brought. I think they were brought the day that the Title III kind of went into effect. And they were brought in federal district court in Southern District of Florida against a number of cruise ship companies that have routes that they take down to Cuba, and where they dock in ports in Havana. And so the suits that were brought by a company called Havana Docks Company, and they brought suits against Carnival and Norwegian and MSC and one or two other lines as well. And so the reason we bring this up is earlier this year, a couple of those suits were actually dismissed on a motion to dismiss. And so that obviously may not have signaled very well for the prospects that people were going to be able to, we're talking now obviously 60 years after the confiscation occurred in most cases. And how is it that people are going to be able to try to validate and bring and litigate their right to potential compensation under these if courts are going to say, well, but it was pursuant to a right that would have expired prior to this date or that date, and view it in a very limited way. And so that was essentially the basis for the motion to dismiss, is that there was a property interest, there was a lease in place that would have expired at a certain time. I believe it was in the early 2000s. And the court dismissed on that basis. So there was a motion to reconsideration filed. And on reconsideration, the court basically acknowledged that they had taken too narrow a view of the property interest. And in any event, that was not a proper use of its discretion or application of the law under the normal federal pleading standards for a motion to dismiss, which are very narrow. And for those who are not federal litigators, you need to accept all well-pled facts as true, and that's how you decide whether a case proceeds or it gets kicked out of court at an early stage. And so the only real reason to bring this up, I think, is that these cases are really among the bellwether cases in these Title III Helms-Burton cases, these cases that were brought by Havana Docks down in southern Florida. And so the fact that there are now these two cases against Norwegian Cruise Lines and MSC have now been reinstated, amended complaints have been filed, and the cases are going to move to discovery, I think is significant. And so these are among cases that people have been watching in this space because they were the first. There's, as I said, there's a couple of others, Carnival and some others that are still ongoing that are all brought by the same plaintiffs. And so now that they're shifting into discovery, it'll be interesting to see how they proceed. I would add as well, it'll be interesting to see if there were a change in the presidential administration, if Title III of Helms-Burton gets walked back and there's some attempt to try to reinstitute the waiver and to take these types of suits off the table. That could really create some messiness if that were to happen late, let's say sometime in 2021 or thereafter. So just a couple of thoughts on that that were prompted by this case.
So it really is hard to predict what's going to happen with lawsuits that are designed to enforce 60-year-old Cuban law property rights in the courts of the United States, which I think is why every president until President Trump stayed implementation of Title III, because it's just created
too messy, yeah.
But so we could talk a lot about that, but because it's the lightning round, I'm just going to say that it has been a very tough 2 months for the cruise lines, and I
Yes.
wish them well. I hope this piece of news is the last piece of bad news that they have to have for a while.
Yeah, here to that. So with that, let's go to our final lightning round topic, which Tim's going to introduce now.
So the final lightning round topic, it arises from this CATSA law that we talked about relatively often on this podcast.
Certainly with one another, we have talked about it way too
all
much.
the time. Countering America's Adversaries Through Sanctions Act, known among lay people and sanctions nerds alike as CATSA. It has one provision of CATSA, Section 231. Section 231 imposes or allows the president to impose sanctions. I think it actually compels the president to impose sanctions against anyone who is doing a certain amount of significant business with the Russian defense industry. It's come up in the past with respect to Turkey purchasing weapons from the Russian defense industry. And most recently, there was an article, and there have been a lot of reporting about Iraq now thinking about purchasing Russian weapons, the same sort of Russian weapons.
The S-400 missile defense system. Yes.
It's a missile defense system purchased from the Russians, and that would trigger automatic CATSA sanctions, or at least theoretically, against the Iraqi purchasers. This is the second time we've talked about sanctions against our ally in Iraq. The previous discussion was when President Trump threatened a new sanctions program against Iran because of their response to the Soleimani killing. And so Iraq is now again in the news, potentially for being sanctioned with respect to a purchase of Russian defense equipment. And we'll see what happens with that. But I do think that it is another example of Section 231 of CATSA having kind of a weird effect, where we have allies, previously Turkey, now Iraq, potentially purchasing Russian defense items and getting sanctioned by the U.S.
Yeah, I mean, it'll be interesting to see what happens. Obviously, with Turkey, there's a lot of talk that Turkey has promised not to deploy them, and there's rumors of some discussions going on with the U.S. to potentially do something about that to avert the sanctions and potentially, I think, get access to other types of defense systems that maybe the U.S. might be able to supply. So yeah, this is a lot of kind of background political diplomatic drama going on, and to Tim's point, I think, you know, on the very first episode of the podcast, we talked a lot about what the prospects really were that sanctions could be imposed on Iraq. Now there's you know, noise that this could be another basis to do that, and things are already a bit frayed after the Soleimani episode. So it'll be interesting to see, and for people that are operating in the region, obviously this is of high significance, and will be something to keep an eye on here in the coming months. Yeah.
You know, you never know when the next ally is going to be sanctioned, so we'll definitely keep an eye on that.
Yeah, I'm still waiting on the sanctions, the Canadian sanctions, which I'm sure will be coming after.
It's just a matter of time.
Yeah, they're just the one ill-placed tweet, and that could result in sanctions for all of Canada. But so I think that's all we have for this time. As we said, please, at the outset, if you enjoyed the podcast, please subscribe, give us a rating. Again, Apple Podcasts, Spotify, Google Play, Stitcher, Overcast, YouTube, wherever you get your podcasts, please check it out. And then stay tuned for the next one, where, as we said, our mystery guest, if we can actually convince him to come on and get a little bit of his time, will be part of what we're tentatively calling China Stravaganza. We love the pithy titles here on Embargoed, so that's the plan for next time, is China Stravaganza in 2 weeks. So stay tuned for that. And in the meantime, who knows what's gonna happen in 2 weeks? Who knows if we're
here in 2 weeks?
Yeah, we might all be living underground in 2 weeks, not even in our homes. And so, in any event, in all seriousness, though, to everybody, please stay safe, stay well, stay home, and of course, stay sanctions free. And we will see you next time.
And for those of you who made it to the end of the podcast, today's code word was OFAC. So every time we say OFAC in the podcast, you should have a Friday afternoon beverage of your choice.
Yes, here to that. So
Stay sanctions
with
free.
that, thank you all. Stay sanctions free, and we'll see you next time. Thanks.